You're in for a treat because we are joined today by someone who I think is in the very front rank of international arbitration. I encourage you to take a look at the very brief biographical description for Lucy Reed in the program materials. I will tell you there's no way of doing justice to her extraordinary resume. But Lucy has been in virtually every important leadership position in the field of international arbitration over the years. She was, before that, in the legal advisor's office of the U.S. State Department, where she served as the U.S. agent to the Iran U.S. Claims Tribunal. She was from 1995 to 98. The first general counsel of the Korean Peninsula Energy Development Organization, in which capacity she led negotiations with North Korea. And of course, today she is a ubiquitous figure in the field of international arbitration, co-head of Freshfields Global International Arbitration and Public International Law Groups, operating, generally speaking, out of Singapore, but again, seemingly everywhere. So we're just delighted, Lucy, that you're here. It's a real treat for me personally, I have to say. And I'm going to just provide a little bit of background for our conversation today. We have some materials that I think may be handed out here in a few minutes, that if not, we'll get them to you during the reception, that relate to a presentation I gave about a year ago. I prepared a report for the College of Commercial Arbitrators, which is an organization consisting of a cross-section of many experienced American arbitrators. Approximately 60% of that group responded to a study that I conducted, a survey of many, many different issues relating to practices and perspectives among experienced arbitrators. This produced a whole variety of very interesting results. It is seldom that we have an opportunity to really assay our peers' perspectives. And we're going to talk about a few of those today. And we have the opportunity to hear from Lucy and to hopefully engage with you on a whole variety of different issues that relate to one degree or another to arbitral neutrality. The people that you choose as decision makers, the dynamics of interplay between arbitrators on an arbitration tribunal, all of these issues often raise subtle questions about the role of not only the arbitrator but advocates and parties. I'm going to begin the different aspects of our discussion with a series of slides that reflect different kinds of data from the survey that I mentioned to you. Let me begin by saying that one of the questions that, or a whole series of questions we raised with respect to these experienced arbitrators related to the whole question of party-appointed arbitrators on what we call tripartite tribunals. A predominant method for appointing arbitrators involves party selection of wing arbitrators, and then some other mechanism, perhaps institutional selection or joint choice, thank you so much, of a chair. And so internationally, tripartite tribunals are the primary mechanism for arbitral appointment. Three-member tribunals. You've heard references to that at several points in the discussion so far today. So we ask a number of questions relating to tripartite tribunals of these U.S.-based arbitrators. What we discovered, first of all, was that most people said, generally speaking, tripartite tribunals work fairly well. They work as well as tribunals set up along other lines. However, we ask another question, or actually ask people to what extent the following statement reflected their own perception. Here's the statement. Arbitrators appointed by individual parties are predisposed toward the party that appointed them, even when the applicable arbitration procedures require them to be independent and impartial. And as you see, almost 90% of the individuals responding to that question said at least sometimes, I believe that statement is true of my experiences. That got our attention. Now, before we talk more specifically about what predisposition means, I'd like to step back, Lucy, and begin by, because let me just say that, among other things, Lucy has written extensively about party appointment of arbitrators, conflicts of interest, and other topics. Indeed, Lucy wrote one of my favorite articles on the subject. She co-authored an article with Doak Bishop. What's it been now, Lucy? 15 years ago?
More than. 1998.
But it was quite, when I first read it, I didn't realize just how old it was, and I thought it was extraordinary. But it actually laid the groundwork for those IBA guidelines on conflict of interest that you heard mentioned earlier. So Lucy is, among other things, a prescient. She's a prophet. But let me ask you, Lucy, when we talk about independence and impartiality, and to one degree or another, this is something that's embodied not only in international practice, but actually in most rules. Leading rules always embrace, in one version of the language or another, these two twin concepts. Let's begin by talking about independence and impartiality and the difference between those two notions, because often they get intermingled.
Well, I will do that, but first I want to thank you for that warm welcome and say I'm not that ubiquitous because I don't go to speak at that many conferences anymore, but when Jack Coe, my long-standing friend Jack Coe and Tom Uask, I'm happy to come. I think it's very important that everybody spouts this phrase, an arbitrator has to be independent and impartial. And in the article that Doak and I wrote so many years ago, I basically took the position that independence doesn't really matter unless the level of dependence challenges partiality. So independence technically means that if I'm an arbitrator appointee, that I'm not financially dependent, for example, by being a law partner or a client or a banker or something connected that would make me depend on the party appointing me for money or a job or something like that, or a next appointments, for example, or a recommendation, which are not, that would make me not independent, but not in a damaging way. So I could say, I really hope that I do a good job and that I'll get another appointment from this firm or that person. So that would, I think, technically make me not entirely independent. But that's not making me partial. Making me partial would be if I'm reliant for my whole livelihood and my mortgage on being appointed by that party. Partiality is favoring the position of the party who appoints you. It is more than an inclination to vote in favor of that party. It's an internal commitment, and at the worst, an express commitment to vote for that party in that case, whether that party deserves to win on the facts and the law or not. That is partiality. That is the worst kind of partiality. The partiality, of course, has gradations as well. It could be because I'm an extremely close friend of the counsel appointing me as an arbitrator. I'm going to find it almost impossible not to assume that his or her position is the best because we're friends and I trust their judgment, and so I'm going to vote for them. And then what we're afraid of is the opposite too. That if I'm too close a friend or too often appointed, that I'll think, oh, everyone's going to think I'm going to vote for them because we're such good friends, so I better step back and vote the other way if it's a really close call. So you want to stay away from partiality. So I would take the position that the test is always one of partiality, and independence is kind of a red herring. But that's not everybody's position.
I think it's helpful in beginning our discussion for you to clarify this kind of your starting point at least, and now we come to this statement and the response to this statement, and we see a sense by the great majority of these experienced arbitrators that, and again, they're U.S. arbitrators, but many of them have international experience as a part of their overall palette. What about this? What does it mean to you? Are you alarmed by the fact that arbitrators that are appointed by individual parties are predisposed? What do you think that means? And where, if at all, does it become problematic?
I'm not alarmed at all. What would alarm me in the practice of international arbitration would be selecting an arbitrator for a client who is not predisposed towards my client. But let me define predisposition, because this is critical. And I'll back up a little to say that we have in the United States, I think, an unfortunate historic conundrum, which is this. In international arbitration, the standard for many, many, many years is to have 3-member tribunals, with each party selecting and appointing one of the arbitrators, and then those two will pick the chairperson, or the institution, like the ICC, will pick the chairperson looking, the selection of the chairperson has generally very objective standards of neutrality, whether nationality or something else. But in the United States, we have this longstanding tradition of advocate, non-neutral wing arbitrators. So in labor arbitration, employment arbitration early on, commodities, maritime, other methods of U.S. arbitration, when the parties didn't have counsel, it was considered normal for, if I were a claimant in an arbitration, to appoint someone I know would vote for me and actually argue my case to the chairman. I wouldn't have a lawyer do that. So a lot of American practitioners over the past 20 or 30 years, as more Americans have gotten into international arbitration, assume that what we call the wing arbitrators, the party-appointed arbitrators, are supposed to be openly partial and advocates, and if they're not open, then they should be implicitly and under the table partial, and going into the deliberations with the chairman with 10 bullet points on why the appointing party should win. That is obviously off limits. It is absolutely crucial in international arbitration that all 3 arbitrators be impartial. And so what does this mean in real life? What this means is, well, 2 things. One, I always say, and I'm sure Kevin and EY, other people here would agree with this, you always sit down with your client and say, here's a list of, 2 or 3 or 5 potential arbitrators. Each one is impartial, and therefore, if it turns out at the end of the day that you do not deserve to win this case on the facts that we can prove and on the applicable law, that arbitrator will vote against you. And I cannot promise you, and I will not promise you, a vote. It's not how we practice. And I'll tell you this in addition, client, if the other party, and it often happens depending on nationality and newness to international arbitration, does appoint his brother-in-law with a guarantee, and this happens, believe it, or law partners, or you name it, then that arbitrator who will be openly partial will not be listened to by the chairman, and you don't need to worry that the other side's arbitrator is partial and ours is not, because that strengthens the deliberations. But let's talk about predisposition. What's permissible? And I've been sitting here today listening to the earlier panels, and it boils down to this. The reason there can be predisposition with a small p is that we're talking international. So I just want to read, I had to reread on the plane actually yesterday what I had written in the article with Doak. And by the way, why did we write that in 1998 before the IBA guidelines? It was because basically we were sick of talking about the topic at the ITA and at every Congress and explaining over and over again to clients what the unspoken rules were. So we sat down and we said, let's talk about the factors that are permissible, like green light factors, when you select an arbitrator, and the ones that are impermissible, absolutely cannot do. You cannot appoint your brother-in-law, get over it, to be your arbitrator, or your father, or your mother, or your spouse, whatever. So those are red lights. You can't do it. But what's interesting is what's in the middle. The possible problems that require more scrutiny, which on the IBA became the orange list, the yellow lights. So we said, let's just write it. And here's what I wrote. Tripartite arbitral panels are a fact of life in international commercial arbitration. When two entities from different commercial, legal, and cultural backgrounds, because it's per se international, agree to dispute resolution by private arbitration, it is understandable that each wants to select an arbitrator who shares that party's background and also has an inclination towards the party's side of the case. And then we had said, I don't mean an inclination to vote for the party. What we mean is an inclination or predisposition to favor that party's side of the case, such as by sharing the appointing party's legal or cultural background, or by holding doctrinal views that fortuitously coincide with the party's case. So if I may, can I illustrate that's a lot packed into some phrases. So what do I mean when I talk about a predisposition to favor the party side of the case by sharing that party's legal or cultural background? Here's a concrete example. I'm sitting on a tribunal now, and again, this is being videotaped. I have to be careful, although this is public. And I am sitting with an English QC, barrister, and a retired Indian high court judge. So that's someone steeped in the English legal tradition. One of the parties is represented by an American law firm, and the other party is represented all by English counsel. And there came a point where there was a witness subject to cross-examination, and there were some allegations of fraud floating around. And after the American counsel finished his cross-examination of this witness and sat down, my two English colleagues said, how could you not have put the question of fraudulent behavior to that witness? You have to put the question or we can't do anything with it. And the American lawyer said, then we had a bench conference, said, what do you mean I have to put the question? We have the witness statements. I don't have to ask the witness, did you lie or not lie? Because we argue that as a question of fact with the documents and you find the conclusions. And the counsel on the other side and the co-arbitrator said, no, when you have a witness, you've got to put the question. You cannot charge a witness with lying if you have the opportunity to ask him, are you lying or not? It was an absolute cold front, hot front, hitting in terms of expectations of practice. It then became, again, I'm not going to give away deliberations because this was in the hearing room, but it was my responsibility as a U.S. lawyer to say, no. That's not how we would think about that case. So you cannot immediately make a finding that there was no lying because it wasn't asked in cross-examination. So that was my translating what the American lawyers were doing to the English lawyers and the English judges.
So,
Yes.
You have a situation like that where you have a culture that says that question must be asked. How much liberty do the arbitrators have to ask the question themselves if they're charged with responsibility of applying not only law but equitable principles, and that's important.
Without agreeing with the second part of your sentence, that they're allowed to use equitable principles, an arbitrator really can ask any question that he or she wants. And that would have been fine, actually, and I've been in situations where that's fine, where an English-trained arbitrator will ask a question like that of a witness. The worry, now this came up in the hearing room, in this case I'm talking to you about, the worry is everybody goes home and you're in deliberations and two arbitrators say, oh, well, of course we've got to drop that charge of fraud because they didn't put the question. And I'm sitting there and I'm appointed in part because I'm an American and I understand American law. If it's an American party and American counsel, and I can say, oh, I don't think that's fair because that's not something we would think to do.
so Lucy, you have a very distinct and I think clear concept of what kind of predisposition you believe is appropriate, whether it's in your own role as an arbitrator or in someone that you're seeking to select. You make reference to the translation function,
Yes.
which is something I know Professor Lowenfeld wrote about approvingly some years ago and said this is something, a bona fide approach that arbitrators may take, and a reason you would choose someone because they're acting as a translator or interpreter on the panel on behalf of a party in a multicultural setting. But there are other kinds of predisposition, aren't there? And
Yes.
isn't this, I hate to use the term slippery slope, but for me, just speaking personally, it feels a bit squishy. How do we know who we're dealing with? You've mentioned two kinds of scenarios. One is the translator. Okay, we'll say that's a benign form of predisposition. And perhaps many people here, most would find that acceptable. On the other hand, you have the inveterate partisan, someone who is an automatic vote, and you're saying, well, they pretty much canceled themselves out in many cases because they're going to be ineffective because it's so transparent that they are partisan. But what about this range in the middle? That's what I'm concerned about. Can you talk a little bit about that?
Well, yes, I can. And let me give another example of what I mean by predisposition when we're selecting arbitrators. Many of our contract dispute cases require interpretation of contract clauses. So it's very common for us in Freshfields and any other practice like this, when we're selecting an arbitrator, we might say, we'd like to find an arbitrator who is really black letter, who has a reputation for interpreting a contract very strictly, which this is a generalism, by the way, but we say, retired English judges, you can always count on them to interpret the word to mean the word and not care that there are 100 documents saying the word doesn't mean the word meant our general intention, and look back at the negotiating history. So if you're on one party in that case, you want someone very strict, but if you're the other party, you say, oh, we want somebody who will fudge, who will think about equity, who will go beyond the pure meaning of the word. And we do look for arbitrators like that. How do we find arbitrators like that? Their commentary, their writings, any published awards. And again, this may sound shocking to some of you, but it would be, again, basically malpractice in international arbitration for me advising a client who wants a strict interpretation of a contract to recommend somebody whom we know is going to be squishy on contract interpretation. It would be insane because you want to win. I'm not talking about something unfair here. Mm-hmm. Now, Kevin, I think, mentioned investor-state arbitration. This is a whole new area because the awards are all published, and there are repetitive issues of treaty interpretation. And we've got an interesting situation now in investment treaty arbitration where there are a group of arbitrators labeled pro-state, always pro-state, always voting for the states, and there's a group who are labeled always pro-investor, always voting for the investor. It's not as true as people think it is, but we would be looking for all of our cases for someone in the middle who has developed a reputation for listening to the arguments of the investor, listening to the arguments of the state, and really applying the law. Having said that, I really do believe in issue conflict, and at Freshfields we have an unviolable rule that none of the lawyers at Freshfields can sit as arbitrator in an investment treaty arbitration, because you inevitably have to rule on what a particular clause means, like fair and equitable treatment, that we can't then turn around and be counsel and be arguing for a client or changing. So that's changing the network or the landscape. But to get back to your question, what I worry about as counsel is arbitrators who are sneaky, who aren't blatant, but quickly try to control the deliberations. Certainly don't like it when two arbitrators speak one language and the third arbitrator doesn't speak that language, and there's a lot of discussions going on that one arbitrator can't understand. I don't like to think about one arbitrator dominating the deliberations or writing too many memos too quickly.
Lucy, you know, Professor Lowenfeld, in writing very candidly about this, and I commend to you his article on his own experience as a party-appointed arbitrator in international cases, spoke about the attempt by parties to co-opt him during the interview process, by trying to get him to stake out a position, or at least tacitly accepting the statements that they're making. There are a lot of subtleties here, and we're learning more and more about cognitive filtering that we do, the cognitive biases we all have. I'm wondering, we're getting to a point now where I think we really are reflecting more on the kinds of biases that can come into play. Do you see this as a potential serious problem?
I don't, if the concept of interviewing an arbitrator candidate is policed as strictly as Andy Lowenfeld wrote in his article, by the way, which is most people I know will agree to an interview of no more than 30 minutes with counsel there for the appointing side, and that as the potential arbitrator being interviewed, you write a note of everything that was asked, basically, and everything you said. And that should forestall the questions that you're thinking about, which are things like, how do you feel about contract interpretation? I don't mean specifically in our case, or on the facts of our case, but in general, are you a strict constructionist or not? That is out of bounds. And I think if people with counsel present ask that question, many good arbitrators won't take the appointment, even if they don't answer because they realize that they're being pushed. To be honest, by the way, the reason most of our clients want to interview arbitrator candidates now is to see if they're going to be alive by the time the arbitrator is over. Just how tired and old and out of it they can be, because these cases can take 3 to 7 or 8 years, right? Kevin's laughing, but it's true, right? You have to know that this person can walk that long. So that's why they want to see them.
We'll take a couple of questions and then we'll move on. Les?
Hi, Les.
I think you may have just answered your question, but given the focus on finding someone who is predisposed, and given the due diligence that you undertake with potential party candidates, what have you learned from the interview process itself, which actually assisted you in the ultimate selection process? That's the question. And I had a comment. I have read your article, and the issue on being other-oriented for a arbitrator I thought was fascinating. I wish maybe you'd spend a few minutes chatting about it.
Which article?
The one you and Bill Fisher.
Other-oriented? I forgot that part.
But that's
Is
a
that
question.
to be an extroverted person in the sense of being a good listener?
That's it.
Yes, okay.
All right, let me ask you this, Lucy.
but let
Oh,
me
no,
answer-
go
The
right
answer is
ahead.
that
Go right
is a
ahead.
good point, Les, because in interviews, it is an opportunity to see how well a potential arbitrator can listen to basic questions and answer basic questions, not cross the line questions, because there are arbitrators who are very egotistical or have become very egotistical, and you do want to know that they can still humbly listen to what you're saying and to speak. So I think that's important. Again, I want to be concrete. I just had a discussion amongst my partners about a candidate, and there's nothing to duplicate that can match the internal knowledge we have of arbitrators sitting in actual cases, and there's no public record of it. It's our experience. And someone's name was on the table, and 2 or 3 other partners said, I wouldn't use that arbitrator again because, well, normally decisive, recently he or she has issued interim orders and then backed away from them, revisited them and revisited them and revisited them. And it makes for a weak tribunal. This is a chairperson. So some information like that is they're not predisposed to vote for you, but you find out they're predisposed to muck up the arbitration. So that would be
All right.
important.
Let me ask this. You had a lot to do with the development of the IBA guidelines. I'm curious to know, here we have all of this concern and focus on potential conflicts of interest. It seems to be more an obsession every year. And yet at the core of the arbitration process, we have this direct selection arrangement where you do have the potential, at least, for a mischief. And I want to show one other slide here from our American study, where here's a second statement. Look at this. Arbitrators appointed by individual parties decide close questions in favor of the party that appointed them, even when the applicable procedures require them to be independent and impartial. Now here we are at the end of the process, and once again you see almost as many arbitrators saying, yes, at least sometimes this is an issue. These predispositions or this bias is going to carry through and affect the final award. Now, you did say something important, and I want to reinforce it, and that is, the United States, we have kind of a unique history here. If you look at the leading arbitration rules, as of a little over a decade ago, they still said that a party-appointed arbitrator, one appointed by an individual party, was presumed to be something less than independent and impartial. They could not be challenged by the other party on the basis of conflicts of interest. Now that has changed. That changed in
Definitely
2004.
changed.
But our Code of Ethics was similar. The Code of Ethics for arbitrators in commercial disputes basically embodied a presumption that party-appointed arbitrators were less than independent and impartial. So the question is this strictly an American phenomenon that we're seeing here, or is this of a larger magnitude?
Well, as far as I know, it's strictly American, the idea that a party-appointed arbitrator should be non-neutral. And for a long time, I think it hurt the appointment of Americans to truly international panels, although that has changed. Although I still see quite a bit leading American domestic arbitrators, when they're on their first international panel, they still do carry that
Really?
with them as a sense of obligation, and I'm as wary of that as I am of retired U.S. judges for different reasons on their first international panels. But But here, I think this data is interesting, and again, it's all American arbitrators, but I think it shows nothing more than where there's a balance on a question of fact or a question of law. It is true that, and I observe it all the time, that the arbitrator will be inclined, if it's truly balanced, to go for the position of the party who appointed him or her. If it's not balanced, they don't.
EY?
Yes. Well, in the three-party tribunal, understandably, the party arbitrator has some disposition or some posing question, direction that the appointed party may like to develop. But wouldn't it risk him to be used by the chair as someone not trustworthy because he's a partisan? So if you choose your arbitrator, who would be a bit of a pleasing the appointed party, you may be satisfied, but wouldn't it risk that he would be discounted by the chair, and then ultimately his voice would be not a strong way? So,
Yes. Yeah, definitely. But if you're getting down to the final deliberations and all arbitrators have behaved well and nobody's crossed the line, then I'm just not surprised at these findings, that if you had to flip a coin as to which way you vote, you would vote for the party who had appointed you. But I don't see it, I don't see it blatant very often.
Lucy, we have too little time, but before we move on from this topic, I would like to ask you, is there anything that needs to be done about this? I suggested that we should have a serious conversation about these issues relating to party-appointed arbitrators and the role they play, and perhaps, if only for people to have the kind of clarity that you have. But I will throw out one possibility, and that is something that is embodied in the CPR rules, which is a screened selection process. Now, this does not prevent the parties from jointly interviewing arbitrators, but what the whole notion of a screened selection process is that the party-appointed arbitrators may be unilaterally selected by individual parties, but they are unaware of who selected them. So, in other words, it's a process that's set up to attempt to provide some of the benefits of unilateral selection without creating the potential for difficulty that we see here. What's your thought about a proper response, if any, to these concerns?
I have trouble seeing how that would work in the kind of cases that most of us do, the big ticket items where the selection process, I mean, even if we went through the normal process and came up with a couple candidates, and so did the other side, and then, say, the head of the ICC court picked two, I think we could guess.
In other words, they would guess who picked them?
Small. They would guess.
Yeah, I wondered about that.
I don't think it would change their view, though. Our former partner, Jan Paulsen, has written a lot recently about the moral hazard of party-appointed arbitrators, and suggested that institutions should appoint all three, always. So you don't have to go through all this. I think that would be fine, actually, assuming that the two things, and Jan and I have talked about this a lot, assuming that the institutions had a really good list of pre-approved, experienced, impartial arbitrators, and that list turned over, say, every 3 to 5 years, so that nobody gets a vested interest in being appointed again and again and again, and there were new names coming in. This has led to a firestorm, however, of discussion with people saying we have a right to name our own arbitrator. And the only, I don't agree with that. The only thing I can think of is what Andy used to say, Andy Lowenfeld used to say, which is, okay, you're going into a high-stakes private arbitration. which under the New York Convention is going to lead to an award that is almost impossible to set aside, but enforceable in 180 countries or whatever it is. And you want to know that somebody knows your legal culture and how you think, and you have some protection in that process, and it's far short of voting for you. It's just someone to say, what do you mean, put the question? Or what do you mean an offer letter that's not accepted in a certain day is going to lead to all costs going over? Because the 3 arbitrators become an island. What if it's all, people of a nationality that hate your religion? What if you have no control? So I think we're back. It's a little squishy, but I don't see that it's going to change anytime soon.
We have a few more minutes. I'd ask you to bear with us while we go through a number of slides and address some related issues, some of which I think a lot of you would probably like to spend a lot more time on. But I am going to ask Lucy for some commentary on some other responses here. Take a look at this. This is the response of experienced American arbitrators, and this is a gender breakdown of the. It turns out that the 15.4%, which reflects the women in this group, 15.4% is exactly reflective of the overall membership of the organization. And Lucy, I have to say, I see this 15% number a lot floating around when it comes to women. Is this a glass ceiling? What's going on here?
Well, I have 2 points to make here on gender. One is that if we're talking about arbitrator neutrality, and the population of the world is 50% roughly men, 50% women, businesses are more and more reflective of women, not perfect yet. It does seem odd to have the vast, vast majority of panels in international arbitration made up of men, older men, Caucasian men, if there's going to be legitimacy in their awards as being representative of the parties appearing before them. And so there's a legitimacy issue, I think, on neutrality. But having said that, I could spend a long time on this, but the reason there are still very few women and certainly even fewer minorities in international arbitration is what I just said. You're in a big high-stakes case, you've got no appeal, it's going to be enforceable, and it's not the time to try somebody inexperienced because of a gender issue or a race issue or religion issue. You need someone who has a really good proven track record, which was the Swiss and the English for a long time. But it's changing ever more quickly, and we see many, many more younger women, younger men as well, and a little bit minorities coming in to international arbitration. So I'm optimistic.
One of the observations I made with respect to this particular group is, as we're going to see in a minute, well, let's take a look at it. I'm going to skip on. A professional background. You'll see that in this group of arbitrators, this is the leading body of experienced arbitrators, at least self-defined in the United States. And you see that only 1.6% of those responding claimed a non-legal background, or at least made emphasis of it. Some of us had other backgrounds, but the fact is all but one person had a law school education. Most were former practitioners, former judges. A point I was going to make before we talk about this slide was the fact that if you look at the U.S. Legal market, you look at the legal profession, women only began to move in large numbers into the profession relatively recently. Even at the time I was in law school, women were still a relatively small minority of practitioners. Now, at the time I was in law school, a lot of my classmates were women, so things did begin to change. But it's taken time for women to work their way up into partnership positions and the senior ranks of law practice and become arbitrators.
And they're stuck at 15%.
But why they're stuck at 15%, I don't know. So, yes?
Just on that point, I, years ago, did a study of the major law firms of this gender issue, and it
More.
has not been reflected in partnership.
Hmm.
It continues not to be, notwithstanding so it's not just a it will happen soon problem, it's a it will happen problem.
And in
Wow.
every other sector too, including professors,
Yeah,
full professors.
absolutely.
But that would be a whole other topic.
And then there's wage equality too, but that's another story. Well, let's talk about this slide just briefly. One of the things that we determined from this study is that a lot of our experienced arbitrators are saying, I am having fewer experiences with multidisciplinary panels. Now, I come from the construction arena, and the multidisciplinary panel was a kind of a time-honored aspect of that, but I find more and more, not without exception, that the panels are dominated by attorneys. I'm an attorney, and most people are on these panels, and it's usually all attorneys. I'm wondering, what's your thought about that? I mean, is this something to be concerned about, rejoice in, what?
No, I would like to see, particularly on construction, engineering side of things, and even on the accounting side, to have more non-lawyers on panels. We're talking about neutrality, though, and whenever I have sat with non-lawyers, if there's an important question of applying the law, really applying the law rigorously to the facts that have been proven to evidentiary standards, a lawyer is better at that
Sure.
than a non-trained, non-legally trained person who will just say, well, but that party tried harder, or, that bridge worked pretty well. So I think it should go this way. So you have to balance that. I think it's important to have the chair in a case like that be a lawyer, but the wings would be more fun if they weren't.
Speaking of the law, this was also subject of a series of queries. Let me read these statements to you. Here's a series of statements we ask for responses to. In the absence of a contrary agreement between the parties, I do my best to ascertain and follow applicable law and render an award. And you will see that the 99% of the respondents, an overwhelming, virtually everyone said always or usually, I make that my business. I'm very concerned about the law. And that certainly comports with my experience, and I will wager most of the people in the room. But let's go on. Again, a similar response to, I carefully read and reflect upon legal arguments and briefs presented by counsel. And now a final statement. I feel free to follow my own sense of equity and fairness in rendering an award, even if the result would be contrary to applicable law. Now again, this is a group of American arbitrators. But I must admit that when I saw that 26% said that at least sometimes I feel that I may ignore the law in favor of my own concept of justice. I was, at very least, I wanted to know what the heck that meant.
I don't know.
It surprised me.
It's so honest. I'm surprised.
Reaction.
Well, my reaction is the same as yours. I'm quite surprised. I think if you could ask follow-on questions, it
Yes.
would be that was on top of satisfaction that the law, the legal requirement, was largely met, or it could be a component of weight of evidence, not that the law says the claimant loses, but my heart and sense of justice tells me that the claimant has to win. It's kind of good. It's kind of human.
Yeah,
I
well,
think, to see that.
in writing this up, I tried to suggest a lot of things that might possibly be going on. We know sometimes that we have a concept of jury nullification here in the United States, as you know, although that's usually in civil rights cases and other places where there's a real problem with the law of some kind. What I don't understand as an arbitrator is usually the law itself gives you the tools that you need to make the right determination, like unconscionability or recognizing the applicability of commercial standards. I've never felt compelled to ignore clearly applicable law. But
what if one party's counsel does a really bad job? Or what if a couple of witnesses whom you've watched fell apart on the stand and got picked apart in cross-examination to the point where you believe that they weren't allowed to say what they really felt, or it didn't match the documentary evidence? That, for me, would be
So that's potentially what's going on
permissible
here.
room to say, in applying the facts to the law, I've got to use the mileage of my career and my experience in commercial relations to make some adjustments. But then you have to write it. So.
Well, yeah. Anyway, this is one where I wish we could do more follow-up. Now here's,
one.
okay. Yes, I was really interested to ask this question, and I'm looking forward to Lucy's reflection on this. I negotiate with other arbitrators when serving on multi-member tribunals regarding the quantum of damages to be awarded. And we see the results are all over the place, but most people say, yes, at least sometimes I do that. Talk to us about this.
Well, I'd be curious to have other reactions, but here's what I think that shows. That shows that the quantum phase gives a tribunal the opportunity, similar to what we just talked about, to, for lack of a better word, do some equity. They could say, okay, on the law, this contract was breached by actions A, B, and C, but we can see why A, B, and C happened. There was an explanation. It was the economic crisis, or there had been, real trouble in that company, or there was an investor, something. Therefore, when we have this leeway to look at all these numbers, instead of awarding the full damages, we can award 80% of the damages, and we don't really need to explain why, because nobody really understands the numbers. And we can say, having reviewed all of the evidence from the accounting experts and done our discount rate and this and that and the other thing, we award X dollars, and it's maybe Z minus 20%. I think that is an area that provides lots more leeway than people believe or appreciate in the deliberations to make up for what can't be done with robust facts and law.
Jack? Mm-hmm.
And point two, footnote, here's where your sneaky arbitrators want to worry about.
The sneaky or sleepy?
Yeah, the one in between that's not,
Yeah.
Both, I guess.
not obviously.
Laurie, you can go ahead and hand those out. Sorry, Jack. Yeah, I will, Lucy, I
I'd like
defer to
you to
you.
answer.
Well, I was curious about this just because I had all of the, among other things, the questions that you've raised and the concept Lucy raises. I think a lot happens at the deliberation phase when you get down to damages. And I think there are compromises of different kinds that go on. I don't necessarily think that is need be a nefarious process. I think it may be, a natural outgrowth of certain dynamics of the process. One likes to think that the arbitrators have done their due diligence and do a rigorous job of applying standards of damages, but a lot of times, there's a standard of reasonableness. It's not mathematical certainty, and I can tell you that in my experience, there will be some negotiation that goes on. But I agree with you. I think there is a lot of potential for the kind of very partisan approach that we talked about to come into play here. And I wonder what you think, Lucy.
I should say this, I don't sit as an arbitrator that much. Being a partner at Freshfields, I'm primarily counsel, so I can't base what I'm about to say on my experience as arbitrator where I haven't seen it. But in the awards that we get, there's reason to be very suspicious that there's a lot of trading off that goes on in the quantum assessment phase. And another thing I've written about when I was at the ITA especially, though, is parties allow that to happen by being way overcomplicated in their damage requests and defenses on damages. So it's incomprehensible, so the arbitrators can get away with that, and I think that can be a mistake. And the other thing is that most claimants overstate their damages. We know in an investor state, the amount of damages awarded to successful claimants is only about 40% of what's asked. So there's a bias. There's a bias against the validity of the claim of damages. And so you say, well, why then as counsel would we let our clients put in high damages? And the answer would be immediately, because we know they're going to be cut down by the arbitrators. So let's give them something to bargain over and cut down, and it goes in that circle. But I really am very impressed with this result, because I think that's where some of the deserved or not deserved inroads into pure neutrality happen.
We have one more slide. I know we're out of time, but I do want to show you this last slide, and perhaps an appropriate place to stop when we talk about concepts of neutrality and the dynamics of arbitration practice. We ask people to what extent is your current arbitration work sufficient? And what you see here is that approximately 41% said we either have more work than we would like or a sufficient amount of work. The rest, almost 60%, said I have less work than I would like, and in many cases, little or none. So, Lucy, part of the dynamic, I think, that we see certainly in the American landscape, and I also believe internationally, is there's an unprecedented number of people, many of whom are reaching the culmination of a career in law, and are looking at becoming arbitrators and mediators. And certainly in the United States, particularly, I'll just leave it at this. The majority would like more work. Do we have a moral hazard developing here?
This is a new phenomenon for me to observe in my career, that there are so many retired lawyers and retired judges who feel that because they've done dispute resolution or litigation their whole careers, they not only are qualified, they're more qualified than other people to be selected as arbitrators in international arbitration. Now, that's not in itself a moral hazard. That's just an irritation, in a sense. But if the moral hazard question is, does arbitrator A, who's been a party-appointed arbitrator, or even if he or she's not a party-appointed arbitrator, but it's one of the biggest companies in the world in the case, feel an inclination to vote in favor of that party in hopes that he or she will get appointed again to fill up the dance card, yes, it is a slight moral hazard, but I really don't see it happen. And that's one area. The IBA rules are very good because they do limit effectively appointments to 2 or 3 over a 3-year period of the same arbitrator. And we also know in the level of our practices, I know other people in this room would agree, I often will recommend appointing an arbitrator who has voted against a client of mine or chaired a tribunal against a client of mine if it's a really well-written and fair award. I wouldn't be inclined to vote to recommend somebody just because they voted. But there are too many people trying to fill too few slots. And so Grant, when you were on your panel earlier today saying it's a great field, it's really cool, come on in, I'd say, well, there's not that much work. So we have to be careful.
It's time to wrap up. We do have a reception immediately following the presentation out in the atrium. you will have an opportunity to speak with Lucy and ask those questions that you're dying to ask. Wasn't this wonderful? I hope you'll join me in thanking Lucy.